Okay, everybody, I'm going to call this meeting of the Judiciary Non-Civil Reeves Committee to order. Everybody needs to know this. I have a 5 o'clock hard stop because I have to pick up my child from his after-school care, and I have to get there. So if we are not done, then it's possible that Chairman Burchett could sit in, but we're just going to play by ear, see how this goes. That being said, there's a lot of people that have asked to speak, and as a chair, I'm asking everyone to pay attention to everybody's testimony that speaks before you. And if we start hearing duplicative testimony, then we're going to probably stop that. So please offer original testimony. So everybody out in the hall there, I assume that you can all hear me. I would like for you to please be dialed in and pay attention to the testimony that is going on so that we can make the most of this time. So with that, I'm going to first call Representative Saines's bill, House Bill 194. And if Tracy, can we get Tracy and the chair of the SORB to come in as well, and they can just have a seat? Can somebody... Hey, y'all. If y'all just want to come in and have a seat here, and then Representative Saines is over here, might as well get y'all in here so y'all can hear everything and be a part of this dialogue. All right, so Saines, you're live, and what I want to do is I want you to go through this bill. I want you to talk to us about, I know that part of this was an effort that we already had passed last year, is that correct? And there are some new aspects of it, and there are some aspects that have been kind of restructured from last year. Is that right? Pull your mic more in front of you. No, it's not working. So let me try it again. Try now.
Hello?
Yeah.
Yep.
Okay. There we go.
So this sub LC 480384S is modeled after House Bill 470. We had broken it up into several bills. This session, this combines 192 and 194 back together. The meat of it, two sections, one being the creation of a split sentence for specific crimes if the offender has twice done such sexual felonies, to create a lifelong probation. Just some highlights of the bill: change of sexual offender registration review board to sexual offender risk review board in line 30, and through this substitute, we're actually going into each offense and putting in that split sentence instead of enumerating it overall. The goes from. Do you want me to list out the offenses?
Well, let me ask you this. The bill's 20 pages long, but isn't it true that a lot of the reason why it's so long is because this is adding a identical language to, I think, what is it, about 12 offenses? And so there's about 12 offenses, sexual offenses, that will have this language added to them, and this language is the same in each section. And that language is what enables, when appropriate, for a judge to be able to give a life sentence of probation for purposes of sex offender registration status, right?
That's accurate, and as well as a what looks like new complete code in section 5.3, starting in line 322, is really code that's been moved from one section to the other. That's why it's all underlined. And if you want a summary,
so I'm sorry, in line 322, section 5.3. Where is this moving from? It's moving into Title 42.
Yeah, and I apologize. This is based on the understanding we had last year that most of this, and I don't think this had any issue when we went on to committee, was that this wasn't creating, most of this is not creating new processes. It's moving it into it. And SORB might be better to speak on this section. I just wanted to highlight that most of that's not new code entirely. It's being moved into it.
And can y'all go ahead and let's go ahead and discuss. And so Tracy, if you want to grab what is that, number 12, number 5, the microphone, try it now.
Okay.
Yeah, pull it a little bit closer to you so everybody can hear you.
Okay. Thank you. for your time. And so I'm sorry, I wasn't sure what are you asking about in reference to
I
it
think
being
we're
pulled over?
in section 5.3, which starts in line 322. And just so that everybody's clear, we're looking at LC 480384S. Is that, but that Representative Sains is saying that this language is being brought over from a different code section to be in what I suppose to be a more relevant code section in Title 42.
Yes, that is correct.
So are there any, and I'm putting you on the spot a little bit, Tracy, but are there any policy changes within moving these code sections, or is it just, is it more of a cut and paste from one code to the next?
I think there's a couple small things that have changed. So I think in reference to through page 16, everything is pretty much the same. No, I'm sorry. So if you look at line 381, one of the changes that we had made was that in the past, the offender had only 60 days to submit documentation for reevaluation, and this now allows them 120 days. So that was one of the changes, and that had been discussed last year as well.
So is that line 386?
That is 386, yes.
Okay, so that actually doubles the amount of time that they would have to submit the documentation. Okay.
Yes. And the next, I know that we did add that we will notify the State Board of Pardons and Paroles regarding classification, which we're already doing, but that just kind of adds it to the law. The next piece was line 395, starting with the second sentence. The sexual offender may request reevaluation after 5 years following his or her initial classification and no more than once every 2 years thereafter. Last year, it was after 10 years following the initial classification, then every 5 years thereafter.
And so let's talk about this change. This is a change that you would prefer that we not move forward with this change. Is that correct?
Yeah,
Tell me
correct.
tell me what you would prefer. You know what? I forgot to have you introduce and tell everybody. I know what you do, but can y'all both introduce yourself and tell everyone what you do and kind of what your relationship is to this issue?
So I'm Tracy Elbord. I'm the director of the Sexual Offender Registration Review Board. I have experience with working with sex offenders since 1992, and I've been the director since 2010. I was an evaluator from 2008 to 2010, and I've gone from there.
And who's the most special person on your board?
You, of course. Other than my chair.
I'm Doug Sylvia. I'm the chair of the board. I have worked on the street with sex offenders for almost 20 years. So I have firsthand knowledge of how they do, what they do, and where they do it. And I have taken this law to heart. And
Move a little bit closer to your mic.
I don't think this is on. Yeah, okay. I've taken this law to heart, and it needs to be upheld and done the way that it should be. And I think we had it right last year, and all of a sudden it's changed on us.
So let's talk about the changes in 396 and 397. Current law is that they may request a reevaluation after 10 years and then once every 5 years thereafter. And now this has been proposal 5 and 2. And so I know that you have a different viewpoint on this. So can you give us your perspective on this and thoughts?
So there actually isn't current law to allow them to have reevaluation past their initial reevaluation. But the board does have policy to allow them to be reevaluated after 10 years, because research shows that after 10 years, they tend to reduce in their risk based on certain factors. And because it's only policy, not in law, there's been a lot of issues in court, and a lot of the defense attorneys are concerned about that, which I understand because policy can change. So we wanted it to be placed into law, but the 10 years, because it's related to research, whereas the 5 years, although risk can decrease after 5 years, it's not substantial enough for a predator to be relevant as far as we're concerned.
And does this classification apply to level 1, level 2 and predators, or just to predators?
To twos and predators.
Twos and predators. And can you, for the committee's benefit, Can you explain level 1, level 2, and predators?
Yes, and I have some material. Can I
Please,
give it
yeah,
to
it'd
y'all?
be great to
Because
hand
I
out.
know visuals are awesome, so.
So what do you tell us what you want us to look at?
So just in understanding the different classifications, it gives you a brief outline in your first page on the left-hand side as to what information we look at to determine their level. So we look at all of their criminal documentation that includes not only their sex offense, but also violent offenses or offenses that could potentially be sexual in nature, such as criminal trespassing, for example. And then we also look at their prison records, because with any kind of intentional exposings in prisons, meaning they're directing it towards a CO, that would be considered, and also violent behavior in prison. And then Department of Community Supervision behavior, being in the community, and then also their treatment records and how they're doing there. So with all that information, in addition to two actuarials that are researched, so we use the 99 and the 2002, which is nationally used, and they are the most used risk assessments in the nation. So we use both of those to give us incremental validity. And that gives us a moderate predictability in risk. And so we also use dynamic risk factors, which would come from your DCS information. And to give you some stats, so for an example, a level 1 offender typically has one sex offense only. They score in the average range on the 99 and the 02 risk assessments, and they tend to have below a 10% likelihood of sexually reoffending. In Georgia right now, based on who we've classified, 58% are level 1 sex offenders. And we've classified 7,178 level 1 sex offenders. The next step, which is your level 2, you have 1 or 2 sex offense convictions. They score above average risk range. They have a sexual reoffense likelihood of 10 to 18%, which is 2 to 3 times more likely to reoffend than a level 1. So that gives you a better perspective on those two different levels. And as of today, we've leveled 32% of the cases we've leveled are level 2s. And then you look at the predators, we have 10% predators that we've leveled. 1,194, and they're 4 to 8 times more likely to reoffend than a level 2 or level 1. So that just kind of gives you a visual perspective on the significance of the different levels.
So the policy is not the policy for level 2s and sexual predators is after 10 years and then every 5 years after that, but it's not codified. So one goal here is to codify this policy as it relates to level 2 and sexual predators. And so Representative Sains, where the 5 and the 2 versus the 10 and the 5, kind of walk us through where this came from. And I think this is a policy decision that the committee needs to make. And I want to hear your input on it.
Yeah, and I am not opposed at all to change it based on SORB's recommendation. I think this change came from in collaboration with the Defense Association, so I'm sure they would have an opinion. I'm sure they'd prefer to stay as is here, but I don't think they would. I think they'd prefer it to be codified. Either way, it's still an incremental win, and I do think that the data that SORB is presenting is sound rationality to move it back from 5 to 10.
And so let me ask you this: with I understand the 10 and the 5 is based on research. Tell me from a practical standpoint, with the resources you have and changing this where the review is this frequent, 5 and 2 years instead of 10 and 5. What does that do from a practical effect for the resources that you have and how you run the organization that you run and how your board handles these?
So on your right-hand side at the back, I give you one example of a case where he requested reevaluation after the 10-year mark, and he remained at SDP. And SDPs, given their level of only 10% are SDPs. It's not a lot.
Mm-hmm.
So that means they're very serious. So them being reduced after 5 years is less likely to happen. So that means that we're gonna be doing a lot of work for no typical outcome of reduction, Whereas at 10 years, there's more apt to be a reduction. So it's going to, and then if it's every 2 years, we're going to be doing a whole lot of work with personnel that we don't have. So, and it's just, so if it made sense, you know, that if we saw that there would be regular reductions at that time, then I would say absolutely, because that's the right thing to do. It's just not going to happen.
Okay. Representative Sainz.
I'd also add to that effect that this bill is creating arguably an increase in requirements with SORB, and an important policy implication for the bill on line two. Trying to make sure I'm giving you the right line. Section 4 and 5. Sorry, it's not on here, but we're actually giving, after 10 years, if they've met certain elements of the crime, they would have the DCS would present to the state, present to the judge if they've met not a level 3 and met certain provisions. SORB would be required to give another leveling at that point and could possibly take away the life. I think it's on 447. I apologize. I'm trying to use PDF type to take notes and it ain't going well. So on 447. So that is, it requires SORB to give that leveling charge. So I would be more in favor of for this instance, to reduce that administrative burden, given that the data doesn't indicate that there's the rationality between the burden on SORB and the likelihood of change would be outweighed.
Okay, so I've kind of completely interrupted the flow of everything today because I'm trying to get some efficiency done because of my time frame. But we did have a question from Representative Lopez, and she had asked if are the two of you supportive of this legislation? And I know that we've got issues with the 5 and the 2 and potentially amending that, but are you supportive of the legislation absent those two numbers?
Yes.
Okay. And I just wanted to just give you an example of predators. I got a call from Pickens County, asked me if I knew a certain predator. And I didn't know him, but they told me he'd been arrested again. And this is his 3rd time in 10 years. Every 3 years, he commits another offense, and he's a predator. So the 10-year rule is, you know, these guys offend and offend and offend. And doing it every 5 years, it's going to kill us.
Okay. Does anybody on the committee have any questions for the author? And actually, Representative Sainz, again, in my interruption of this, can you walk us through the 11 or 12 offenses that are adding this consistent language that would allow the option of a life probation sentence? Walk us through those offenses, the logic of why they were added, and also talk about the discretion that what the mechanics of the legislation calls for, and the discretion as far as who actually would be geared at and who it wouldn't be, and how that would work. Can you help us with that?
Sure. So it's important to note on any of the mentioned offenses in the bill, it must be a twice adjudicated offense. So it's not I don't think it's a plausible anymore, but if a circumstance where there's two offenses for the same action, that wouldn't be applicable. But it is related to ag, assault with intent to rape, starting line 43, kidnapping in line 59, trafficking in line 82, rape on line 93, aggravated sodomy line 103, statutory rape 113, child molestation line 123, enticing a child line 134, improper sexual contact by an employee or foster parent is 145, and incest is following thereafter. And then on line 172, it encapsulates the summary of sexual felony, and it also enumerates those offenses. And those offenses were, instead of doing, I think it started with felony sexual offenses in general, and I think there's 1 or 2 that the committee felt weren't applicable to the intentionality of the bill being trying to target dangerous sexual predators, given that the Supreme Court decision in State v. Williams made it to where Georgia sheriffs did not have the flexibility after an individual was out of their sentence to GPS monitor. This bill is not going to be a fix-all because it's a very limited scope based on Department of Community Supervision data they provided. If this bill were applicable, which is not to everyone in the system today, it would be 53 individuals, I believe, roughly. So we're talking about a very limited scope of individuals who would follow in this law, but it is targeted to those limited individuals that are the most likely to require or to be leveled as dangerous sexual predators, knowing that the state no longer has the ability to utilize what is a very crucial form of deterrent, which is electronic monitoring on these individuals. With that, there's also a safeguard in place where we are being cautious out of necessity on the front end, but starting in line or section 5.5, line 430, there is the ability for the petition, and not through the individual wouldn't require an attorney because it's being requested through the state, for the state to look at if this individual really fits into this life sentence. So yes, it is a life sentence for these crimes, but in reality, it's a safeguard that does have a provision and a mechanism to take it away if it's inappropriate based on the leveling of the individual and the actions thereof.
And isn't it true that this committee in the House, right, passed, it's structured differently, but we passed, by all intents and purposes, a version of this last year, right? But there's been some work in the off season, and I think, frankly, my opinion is that structurally it makes more sense now. I think it's cleaner now, and so I mean, do you agree with me? I'm leading you with questions right now. That's okay. I'm allowed to do that. Do you agree with me that this is an improved concept on a matter that passed this committee and the House of Representatives a year ago?
I believe it's been bathed and washed by this committee as much as possible, so I don't know what dirt would be left on it.
Okay, McLaurin, I'm going to put you on a very short time frame because we're already exponentially behind.
I can do this in 60 seconds, Mr.
Okay.
Chair. To the author's point about there being a little dirt left, in keeping with your intention, any offense that you don't insert language in the actual code section, you did not mean to leave in the final list, right? If you took sexual battery off, if you took computer and electronic pornography and child exploitation off, you did not intend to leave those in the final list of offenses. Defined sexual offense, right?
You're speaking to lines 172 to 197.
I'm speaking to, yes. So specifically, we're talking about 192 to 193 and 196 to 197. My understanding is that you did not intend to leave those lines in the bill. Is that correct?
I believe that could be a grammatical change in terms of defining sexual felony. I defer to legislative counsel in case that has implications that I'm not currently seeing, but as it relates to the bill itself, in terms of creating the split sentence, they are not listed.
Right. Okay. So I think that might be an area for cleanup. The last question I've got, because you all know I disagree on certain aspects of policy, namely mandatory life electronic monitoring, but line 103, felony offense of sodomy or aggravated sodomy on page 5. When I heard you go through each of the offenses, which was helpful, thank you, you just mentioned aggravated sodomy on that line. And my understanding is there might be constitutional issues with just regular sodomy and that was never part of the intention. So would you be amenable to an amendment to remove sodomy or from line 103?
The intention is for aggravated sodomy, which would have the only actual policy implications, and sodomy is found by the court to not be something that's enforceable. Again, I'll defer to legislative counsel if it has any policy implications by not having it on there. I think that was questioned earlier on, and they said that it's standard to have, since it is the same code section, I believe, to have it on there. But if it's the will of the committee, I don't think that would have a policy implication to modify.
Okay, those are my only 2 points.
And I think that I would like to hear legislative counsel's thoughts on that as well, because I think that the official code of Georgia might be due for a cleanup on that word, but I don't think anybody has done that. And so I guess the question would be, I think that there's probably consensus that word could be removed from code, but in doing so and not doing it all at the same time, or having there be inconsistencies, would that be a problem? And I don't know, is legislative counsel on the, Ms. Carter, can you give us, if you're on, can you opine as to the necessity of the word sodomy in line 103.
Yes, I am here. Hold on one second, please, while
Okay.
I go to the line. No, this is one of those offenses, I think, that they list like for sodomy and aggravated sodomy, child molestation and aggravated child molestation. So if sodomy needs to be removed and we need to go with aggravated sodomy, that should be fine. There shouldn't be anything.
We don't create any consistency issues by doing so. Is that
No,
right? Okay.
I don't believe so.
And to Representative McLaurin's point about, and that this bill's been amended as recently as this afternoon. And so there was a prior version of this bill that I had gone through thoroughly, but I haven't had an opportunity to go through this thoroughly. And so going back to the section 2-12, which is the sexual felonies, lines number 12 and number 15. Number 12 is the second offense for sexual battery. Number 15 is computer or electronic pornography and child exploitation. Are those references under sexual felonies, are they accompanied with another section? Do we have clarity on that there is not another section in the bill that references back to number 12 and number 15? Is that right?
Not any longer, as of the amendment that I was given by Representative Saines to take out the computer and any sort of obscene material. And those, I think those were also eliminated. I just didn't take them out with the revisions of this particular version, but they were not, if there are leftovers from the earlier information that was omitted for this version, then we can just take it out. It was just an oversight due to the quickness of the amendment need to amend the bill for today.
Understand. We're at that point where things change fast, and we're thankful for Representative McLaurin for catching this. So all right, understanding that upon an amendment, those could come out and we could remove the word sodomy. Does anybody else on the committee have anything to say before I start getting to these witnesses? And time is just not my friend today. All right, let's bring in Vic Reynolds and Liz Bingham, I think. If Director Reynolds and Liz Bingham, if y'all can come in the committee room, and if y'all want to maybe go sit in the back right there so that we could still have your expertise present. You're gonna have to go right and left. Y'all could come up to these seats right here, Director Reynolds, this middle one, and then the one over here with the microphone. Right here, the center one. And so thank you for being here, my very good friend,
Yes,
Director Reynolds, and my constituent, Director Reynolds.
Absolutely. Good to see you, sir.
Y'all had signed up to speak, so why don't you talk us through what you've got to say.
We'll be very brief, Mr. Chair. Thank you for the opportunity. Mr. Scandalakis, who is another dear friend of mine, will be in here in a moment to recommend the addition of some language under Code Section 1612-100 regarding the prosecution of possession of child pornography. That language is very brief. It's verbatim for the purposes of determining the unit of prosecution under this section. Each depiction or image or of visual or printed matter constitutes a separate offense. I just wanted to go on the record and say that the Georgia Bureau of Investigation was very much in support of that language. Ms. Bigham, to my right, is actually assigned to that unit, our SEAC unit that works those cases. And I just want the committee to know that when her group works those cases, we're not talking about usually 1 or 2 or 3 or 4 images. We're talking not only hundreds, but thousands, sometimes tens of thousands of images that are downloaded. There was a case that came out in, I believe, October from our appellate courts that held that the way the language is written now under that statute, that a single image or 1,000 images would all still be counted as a single count if it was downloaded at the same time. And Liz can probably give a few more facts than I can, but it's not unusual for these perpetrators to download thousands of images at the same time. And so Mr. Scandalakis, on behalf of PAC, is going to ask for that language to be added. I just wanted you to know and the committee to know that this Bureau stands very much in support of that language.
Okay, great. Anything else to add? Any
No, Liz,
questions for the
anything else?
GBI?
No, not unless you have any questions.
It appears that we do not. So thank y'all so
All right,
much.
thank you.
And let's have Mr. Scandalakis and Mr. Smith come in.
Good to see you, Bert. Take care.
Good to
Thank
see you. So. Okay, the clock is ticking against us. We have a hard stop at 5, and we're not going to get to all the bills, but why don't y'all, my understanding is that y'all have requested some language to be put into here. So why don't you talk, let's cut right to it and talk
Correct.
about it.
Mr. Chairman, under the appellate decision, if you have 10,000 images of 10,000 different children being molested in 10,000 different ways, and I'm talking about children as young as 2, sometimes, even younger than that, all that merges into one count, and you can only charge it as one count. It rewards the prolific child pornographer. And we want that fixed because we don't think that was a legislative intent when you said any.
Can you point us to where the fix would be and what it would be?
I'm sorry, pardon now?
Can you tell us where it would be, Bill?
Robert?
Mr. Chairman, you could put it in any subsection. You basically create a new subsection in 1612-100, like H, if you wanted to, which I think the most recent substitute of the bill. I apologize, I don't have the exact line number. You could put it in after line 200 in 480384S. You could put it in as a subparagraph H to solve the problem.
Are you looking at a different bill than I am?
I've got LC 4
Line 200 doesn't seem to be the
220.
line 220.
Yes, sir.
So that would insert another section. So what this would be a 16-12-100 or H, is that right?
Yes, sir.
And so it would be H, for purposes of determining the unit of prosecution under this section, each depiction or image of visual or printed matter constitutes a separate offense. Is that right?
Yes, sir.
And placing that at the end of section 16-12-100 would be the appropriate place to do that.
Yes, sir.
Okay. Thoughts from the committee on this? Representative McLaurin.
Mr. Chair, I don't feel able to have a productive discussion about this given the time constraint. I just want to log for the record. I wish we had more time to talk about this. That's frankly all I have to say.
And so the policy decision that we're looking at right now is that whether you have 1 or 10,000 images, you are subject to the same counts. You're subject to one count.
One count.
You being indicted under one count.
Yeah, you could introduce, and one thing I think, and this may go to one of the concerns that Representative McLaurin has, is that I would anticipate these would not be duplicate images, identical duplicate images, because that's not what we're talking about. Obviously those images would not be included. I'm talking about separate, distinct images of separate, distinct victims of separate, distinct acts is what I'm trying to get at. And I don't know if that addressed your concern, because you would hate to introduce 10,000 pictures of the same act, same child, and have that be, 10,000 acts or counts.
And also, if I may, in the definition, film is broken out separately. So it can't be an instance of you take a film, like a 10-minute film, and chop it up into millions of little images. A film counts as one item
Okay.
or one depiction.
Here's what I'm going to do. The will of the chair, I don't know what the will of the committee is, but the will of the chair is to move this bill out of subcommittee today. And what I would like for us to do is, if the chair is on board with this, is on the same page as me, is to look at, in the interest of time, as Representative McLaurin said, to be able to look at this and explore this a little bit further for full committee, and potentially, offer the same thing, but with a little bit more time to digest the concept of whether or not, if somebody has 1,000 photos, is 1,000 count indictment appropriate? Is there
No.
some kind of tier system here that might make more sense in the eyes of the law than one count for each photograph? And so I think that there's some things that we could work through on that we can handle at full committee. Is
And
that
perhaps we could refine the language too for you.
I think that would be.
So we're not talking about duplicate images of the same thing.
I think that would be prudent. And so why don't we work? In fact, why does it? What I would love to do is have Representative McLaurin be involved with helping to work on working with y'all on some language to resolve that in a way that makes sense and is prudent, and we'll work with the author of the bill, obviously. So, Representative States, do you have anything to add to that?
No, the only hesitation to have added it was just because we had to refine this so much. So it's a practical hesitation. It is a significant policy. It has policy implications. So I do think it's wise to vet it out.
Okay, I'm gonna have Ms. Travis. Ms. Travis, can you unmute yourself and talk to us?
Sure. Am I talking to you about the entire bill now?
Yes, the floor is
Okay.
yours.
Okay, great. Thank you. Good afternoon. I have to lead with your initial comments, Mr. Chairman. When appropriate, those are the specific words you used. When appropriate, the judge should sentence somebody to a life sentence. The difficulty is you've completely removed when appropriate. Instead, you've said that the legislature says in all instances when this is a second offense, you must impose a life sentence, Judge. You don't have any discretion. I'm sorry that these.
Where are you in the bill? And sorry to interrupt you, but tell me where you are, what line you're on.
Okay, let me take you to. Sorry, my pages are sticking together. It always happens when you're trying to go fast. Throughout the bill, I'll start at line 44. Shall be punished by life imprisonment. Shall have life monitoring. That's at line 46. At line 61 and line 63, line 83, line 85. I can go on through the entire bill, but if you changed shall to may, that would make a significant difference, because what would it do? It would give the judge the specific discretion that she should have to be able to evaluate these cases. Why? Because not every case is different. Just because somebody has a second offense doesn't necessarily mean that the first offense was rape. If it was rape, certainly that might be a different instance. We've got examples. I just want to give you a couple of them. And many of you, or those of you that are from smaller communities, are familiar with the instance where a 21-year-old man who maybe doesn't have as quite developed of a brain as he should, has sexual relations with a 15-year-old girl who may look like she's more like 17. Maybe they end up actually getting married, but that's statutory rape in this part of the world. And there's a lot of instances where young men and women that are girls because they're 15, but who maybe don't act like girls, get involved in situations that they shouldn't. We have another example of somebody that was charged with enticing, where a man tried to call his adult girlfriend, but instead called the phone was one digit off, called a 14-year-old girl. The girl went to church with, this is in Rome, went to church with the judge in the community. He was charged with enticing a child. And, you know, from there it unravels, and that's the first offense, but I realize that it's a second offense, but I'm just saying that's how easy enticing a child would be to prove. This whole instance where you're talking about the imagery, again, that's section 2-14. It's definitely viewing, not doing. So I would ask that you would take into account that enticing a child, statutory rape, and the computer pornography crimes be taken out of the bill, and you narrow the scope of what you're doing. The may to shall,
Tell me those offenses again. You said stat rape.
enticing a child, and it's sexual exploitation of children. It's section 2-14 in your bill. And I want to point to Tracy's testimony that lets you know that SORB had 10% of its crimes, or 10% of its population leveled as a sexually dangerous predator, which is an important feature. And what you're doing, Mr. Chairman, is when you take away the discretion of the judge, you're saying that 100% of the people in these circumstances have to have lifetime monitoring and have to have lifetime sentences. So changing the mays to shall would be a meaningful.
You mean changing shalls to may?
Yes, I'm sorry, changing. Because what you want to do is you want that the most dangerous people and the people that we need to keep track of be the ones that are on monitors. And I know, Chairman Reeves, that you have a lot of confidence in judges. We have a lot of confidence in judges too. And we really want them to be the decision makers.
The let me say this. I think that you raise a good point with the offenses that you've raised and the importance for the judge to have the option on some of those. I think that there's obviously some of these crimes that two strikes, and I think that we have pretty good consensus that a life probation is appropriate, but that there are probably potentially there are scenarios where some of the lesser offenses, which are still egregious offenses, but having the option as opposed to the mandate could be valuable. And so what I'm going to intend to do is work with the chairman between now and when the bill comes to full committee. And look, I have a backlog of bills right now. And so my intention, if it's the will of the committee, is to move this bill today, but we will also work on that before we bring the bill to full committee.
I will tell you that to the extent that we can be agreeable, we don't have any objections about kidnapping, trafficking children for less than 18 years of age, rape, egg sodomy, child molestation, and egg sexual battery. It's the rest of the crimes. Enticing also is, you're familiar with sting operations. That's one that gets brought in. I can give you a list of the ones that we have concerns about if you want by email.
Please do, and then I'll work with the author of the bill on a middle ground on those things. But your point is well taken. Are there any other matters of the bill that you want to direct our attention to?
I don't think it would be productive to say that we disagree with the changes that are brought by the Prosecuting Attorney's Council in terms of adding this to the bill. I think Representative Saines is smart to have concerns about what this would do for the bill and how it could affect it moving forward.
What he's smart to have concerns about? I don't understand.
About adding PACS changes to the multiple imagery.
Just in the spirit of conversation, what are your thoughts on what I had suggested as a possible tiered level, where meaning 1,000 images do not equal 1,000 charge indictment, but have a tiered level of, and I don't even know if it's possible. I'm thinking out loud, which is dangerous, but do you think that there is a way to capture the issue there?
Truthfully, I don't know that. I'm computer dumb. I'll just tell you that. And downloading stuff, I don't really know as well as I should. So I don't know, when I hit a button, sometimes the right thing happens and sometimes the wrong thing happens. Maybe I'm trying to download one document or one image, but it's a file and it has 40,000 images on it, but I really just wanted to look at the one image. Does that get counted the same way? Does it matter if I clicked on all 40,000 images? I don't know enough about the mechanics of this crime. I do know that one image carries 5 years. It has a 5-year sentence already, so it's not like a light punishment that is involved in it. I can't tell you if tiered works best.
I mean, I think that this may be a hard issue to solve academically, but I think that there is a significant difference between somebody that has one image versus somebody that has 10,000 images. And if there's a way to account for that, then I would like to see us work towards that. And we welcome you a seat at that table, Ms. Travis. So
Happy to be there.
Mr. Chairman, there was one other ask we had.
please.
For consistency's sake, in lines 447 through 466, which is section 5-5 about the termination, this is the only section that doesn't have a provision in it where a notice about the early termination would go to the prosecutor, so the prosecutor could comply with the constitutional amendment to notify victims. And that's all. That's the other ask, is that if something could be put in. I'm sorry, I'm going quickly because I realized we were low on time. In section 5-5, when it talks about early termination, this is the only time when termination is discussed that the prosecutor is not given notice. And we're asking that we be provided notice of the intent to early terminate so we can comply with our constitutional responsibilities to notify victims that the offender's sentence may be altered.
Do you have language to?
Isn't
there some standard language on that? I don't think that it's anywhere in this draft that we're looking at, but isn't that
in the code section? Yes, sir. And I'll be happy to provide that.
okay? So what I would prefer to do is to look at that, add that to the list of things that we're going to discuss in the next 24 hours, and be looking at a sub for full committee. So what I'm going to do is I am going. Chairman Burchett.
I'd like to offer a motion when the time's appropriate. And I think we have at least an idea what we're going to do here. And we've got several amendments that are going to be made and some language added. So for the sake of time, I agree with the chair in that we move this to full committee and not necessarily, push it through Representative McLaurin, because we want you involved. But move it on to the next part of the process and let everybody get their insight in there. That's what I was asking, Chair, at the appropriate time. I'd ask for.
The time is appropriate.
A motion to pass.
Okay, is there a second? Okay, so there's a motion and a second. Are there any amendments? I would like to propose what I'll call the Reeves Amendment 1, and that is to, on line 103, to strike the words sodomy or. Is there a motion and a second on the Reeves Amendment 1? So you seconded. Is there a first? Yeah, so moved. Oh, okay. I thought you said second. Is there a second?
Second.
Is there any opposition to the Reeves Amendment 1? Seeing none, Reeves Amendment 1 passes. Reeves Amendment number 2 is on lines 192. I move to strike 192 and 193, and also strike 196 and 197. And renumber on line 194, that will now become the number 12. And on line 190, did I do that right? 11, 12. Yeah, so line 194 will become the number 12, and line 195 will become the number 13. Did everybody get that? Chairman Burchett.
So moved.
Okay, so there's a motion. Is there a second? Any opposition to Reeves Amendment number 2? Seeing none, Reeves Amendment number 2 passes. Was there any other amendments that we can do today, or are we? Okay, and then I would like to propose Reeves Amendment number 3 on lines 396 and 397 to change, to strike the word 5 and put the word 10 on line 396, and to strike the word 2 and replace it with the word 5 on 397. Is there a motion?
Motion.
Is there a second?
Second, if it wasn't.
Okay, all those in favor of Reeves Amendment number 3 state by saying aye.
Aye.
All opposed?
Aye.
All right, so we have at least one opposition. Anybody else online opposed? Actually, Representative McLaurin, I love you, but you can't vote on this committee, so.
Chair, I'm opposed as well.
You remain our poet laureate, but you are not allowed to vote on this committee. Representative Bodie.
Yes,
Are
I'm
you no?
opposed. I'm a
sorry.
no.
Okay,
Yes.
so the ayes have it. Reeves Amendment number 3 passes. We know what we need to do before the next committee. We will work towards that and have a sub, and we will move the bill on to full committee.